Hi there, this is Erica Marilyn. I am the founder of Perfect Legal Video, and I am very excited to have with us today my favorite guest, attorney Nicole Reeves LaVallee. She is a family attorney out of Worcester. She owns her own law firm, and she is often here with us on Friday afternoons, just imparting her great wisdom on a plethora of topics. Now, typically we talk about family law, but we sprinkle in a little bit of real estate here and there. Today, we're going to be talking about titles and all of the different ways you can hold a title. So I wanted to welcome you today, Nicole. We appreciate your taking the time out to talk to us about this very important topic.
Thank you. This is a topic that people don't understand until they're going through a divorce, until they're going to sell a property. They really don't understand what the ramifications are. And it's really sad because you really should know what you're getting into when you're buying the property. So I just want to educate people and so that they understand what their rights are, both when they're going through a divorce as well as when they're purchasing it, and what is best for them in that particular situation.
Yeah, I think you're right. I know a lot of people, when they're going to go through a divorce, they end up just like, oh, it was so long ago. Whose name is on the title? Do I get the house? If I get the house, how do I get the title? I think those are some of the first questions you must get in regards to property when somebody's going through a divorce. Is that true?
That's true. However, there's a step before that, which is when they come into my office that very first day and I say, okay, and you own this house. Well, who owns it? Whose name's on the title? And they go, I think it's joint. And whose name's on the mortgage? Oh, well, that might be joint too. Or maybe I'm only on that and he's on the mortgage. And we go through this, and every single time I'd love for people to just go, oh, I know what it is. So it's a very telling thing that people don't know where they stand, and they should know. So you always need to know where that is. And again, you should be knowing that before you're purchasing.
Well, I think that has a lot to do with how people just rush in. They're blinded by love. They get married, and they really don't think about marriage as one of the biggest financial decisions that you can make in your entire life. And part of it are some of the big purchases that you make, such as a house. That's a big mortgage that we're talking about.
Yeah, and it's, sometimes it is driven by the person that can afford the mortgage. Sometimes it's, hey, my spouse can't be on the mortgage because their credit score is 300 points, and that's not going to get us anywhere. Or, they've got really bad debts and there's people looking for us in judgments. And again, you want to stay away from that. Maybe that's when you don't want to have your spouse on it, because again, if they have a business or something, or they're prone to having judgments, or they have judgments against them, you want to make sure that house is protected. So those are things where, as a couple, you're probably making that decision for one of those reasons or another, that I want to own that individually. And that's obviously simple. If we own it individually, it's individually. And in terms of a divorce, that doesn't mean it's only that one person's. We're still a community property state, so it would still be jointly held by the two of you as an entity. But on the deed itself, it will be only yours. What I'm talking about today is, okay, so we have two people's names on it. Now what? And that's really where people don't understand. There's a lot of different types of ownership where we have multiple owners. So just for an example, most people that are going into a relationship as a married couple, I'm going to tell you unequivocally, without a doubt, if you're going to hold it jointly, it should be tenants by the entirety. So to say husband and wife, or spouses, tenants by the entirety. What that does is that protects you against anybody else under the sun. The only way that this property can be sold is with husband and wife selling the property. And so you've got that absolute protection. And if, God forbid, one of you were to pass away, it's going to go to the remaining spouse automatically. You don't have to go through probate. So you're eliminating that. So that, I'm going to say, if you're going to put both names on a deed and you're married, it absolutely has to be that. But there are other ways you can own it with a situation where there are multiple owners, such as joint tenants. And a lot of times what will happen is we're engaged, we're loving, and we want to get married, and we want to buy this house first, and then we're going to get married. So a lot of times that's when a joint tenancy would come into place. That's a joint tenancy with rights of survivorship, and that's key language that we need to have. But what that does is kind of gives you similar rights to the tenants by the entirety, and it allows you to, if one of you were to die, then it automatically conveys to the remaining person that's listed on the deed. So that gives you an ability that you have that you can protect yourself. Now that being said, you're going to buy that house as a fiance and a engaged couple. When you get married, again, I'm going to say, hey, let's go redo that deed and let's change it to tenants by the entirety, because again, that's going to give you absolute protection. Why? Simply because if you have joint tenants and one of you decides, I'm not going to get divorced, I'm not going to go through divorce proceedings, but I'm going to sell my portion to my brother, congratulations, now you own it with your brother. Where in tenants by the entirety, it has to be sold as a married unit. You cannot sell your half to one other person.
Ooh, so this is a really good gotcha for people to know. And I bet a lot of people don't know. Now I'm going to just add one little layer on that. What about, because I know that everyone that you work with, you do a lot of other type issues with family law. It's not just divorce. Sometimes people break up and they never got married, and they may have bought a house together. I mean, is it the same advice that you're giving?
Yes, potentially yes. So obviously, again, I'm going to probably recommend, based off of their circumstances, that joint tenancy relationship. There is one other type of entity that parties can hold, which would be tenants in common. Maybe this is not a dating relationship. Maybe this is more of a brother-sister relationship or something like that. So those types of relationships may have different intricacies. So it's something to be considered, but obviously you can have joint tenants or you can have tenants in common. What tenants in common is basically you own it. So I own it with Erica, and Erica passes away. Sorry about that. What ends up happening is that your portion goes to your family. So now I own it with your family. So whoever you left it in your will, that's who's going to get it. So it's a little bit different where in the joint tenants, it's automatically all going to go to me in that scenario. Now I'm going to own it with Erica's family and whoever she designated. So that's something that you would want to do. Again, if it's a brother-sister situation, maybe you want to give it so that your spouse is going to get that property rather than your brother. Just something that you want to make sure that it stays in your family. And so there are those available options, just again with an individual component that you can protect your family and you can protect this property.
Well, thanks for killing me off in that example, Nicole.
Anytime.
I mean, those are really good caveats that you're talking about. I mean, honestly, if I was to buy something with my sister, this would still be, part of my nest egg. It's not necessarily like she's the one that I would want to give everything to in my will. If I did in fact have a daughter, and I do, I'd probably want to put my half in a trust or something for my daughter. I mean, and that's tricky. And I know that's part of what we're talking about here. Maybe you can address the issue of holding a title through a trust.
Absolutely. That's definitely one of the other ways. Obviously, I just talked about the 3 ways that multiple people can own individually, but an entity can own. So a trust can own, and you can have obviously an irrevocable trust or a revocable trust. I'm not going to get into the differences today, but it sounds exactly what it sounds like. Irrevocable means that person can't change it. That's the simple terms of it. So you can have a trust set up, or you can have a realty trust set up. So it can be obviously for the benefit of heirs, whether it be a revocable or an irrevocable trust. It's set up for the benefit of certain heirs in your family. Sometimes it's a family member like a minor child, and you're kind of thinking about their future and their college and whatever. That's what you can contribute to them. if God forbid something happens. Or in the other avenue is that maybe it's a realty trust. Maybe you're an investor and you want to invest in multiple properties, have all of them in one realty trust. So again, for tax purposes, you're not going crazy and filing 20 million tax returns, or better yet, having it on your own. That's a way that you can do it. So there's different types of trusts that you can set up that will have different purposes. And obviously the trust is going to dictate who the heirs are and when they would receive it based off that trust document. But obviously, when you go to sell, there are certain extra things that we have to do as the seller.
I mean, that's really great information to have. And I mean, I guess, what's your favorite way to hold a title? What do you think is the best way?
Again, it kind of depends on all the options and what you're doing. I think realistically, I think your best bet is, again, if you're a married couple, do the tenants by the entirety, kind of a no-brainer. If you're some kind of business entity, or you're doing it where there's some other underlying business, either an LLC or a corporation is another option. I would always choose a corporation. Corporation gives much more protection to the business owners. So as a corporation, you basically have complete and absolution of doing any wrongdoing, except for gross negligence, which you're never going to avoid. So it's something that's going to give you a super duper protection as far as a business owner. Obviously, you file corporate tax returns if you're a landlord and maybe you're buying this real estate and it's a 6-family unit and it's collecting income. That's all going to go under the corporation for tax purposes. So it's not necessarily going on your income. So it's just something to worry about and think about and talk to your CPA about, because it's certainly something that has protection. The CPAs are all going to tell you go with an LLC. And so the attorneys and the CPAs always conflict on this. Apparently, and I can only say that, but apparently LLCs have a lot of good tax ramifications. So a lot of people want to set up an LLC and have this real estate property in an LLC. That's great. The problem is it doesn't give you absolute protection. It gives you limited liability, which is in the name, limited liability company. So you have limited liability. So you have exposure. So again, from an attorney standpoint, I want absolution. I want to stay away from everything. I want nobody to be able to touch me. From a CPA standpoint, I get that you're getting tax breaks, but I don't know, in my opinion, that the tax breaks are worth the potential liability in a lawsuit. So it's definitely something that people need to worry about. If you're doing a trust, I'm going to say do an irrevocable trust, but there's ramifications for that too. So there are so many advantages to these 3 things in these different areas. But I would say top 3, again, individual or multiple owners are going to be tenants by the entirety. Your best thing for a trust is going to be an irrevocable trust. And the best thing for any kind of corporate entity is going to be a corporation versus an LLC. Again, every one of them has different things that have pitfalls. But in the legal realm, those give you the most protection against anybody that's potentially going to sue you.
I mean, that is really good information. I mean, and that's the biggest fear that people have, is that for any reason, somebody can sue you. And if you have property and you have that kind of liability, then you really need to be protected in some way. So I'm glad we've gone over these ways. Is there anything that is different about business property versus the residential ones that we've been talking about?
You can hold title in any of these things, any of these ways. Again, obviously, if you're talking about commercial property, you're talking about multi-families, anything more than a 3-family, absolutely, it should be some kind of entity, some kind of legal corporation or something to protect you. Again, as you can technically own it as a DBA, but why would you? Because you're getting zero protection and you're exposing yourself to full liability. The only thing that I would definitely say to add to that is, again, depending on who the owners are and what type of entity you have, you got to remember and think about homestead. So declaration of homestead is going to protect you against any outside creditors, whether it be I come to your property, you invite me over, I slip and fall because you didn't bother to shovel, and I sue you and I get $1 million. Great. That doesn't mean I can take your house out from underneath you. I can have that judgment, but I can't force you to give it to me until and when and if you sell the property. So you got to think about things like that. And certain entities, like a corporation or LLC, you cannot have that declaration of homestead, but in a trust you can. So again, there are going to be pitfalls for everything, and that's why you definitely need to set up an appointment with an attorney before you purchase that property, and even after you purchase it. It doesn't hurt you to take a second opinion and can take a look at it and see, is this my best protection? Because maybe when you purchased it, you were working for National Grid, except now you've decided to go on your own, and you have your own business. Now you need to know what that exposure is. So it's definitely something that you should know what you have, you should know what your protections are, and you should know how to best protect you and your family.
Well, I think that this is sage advice, and I'll echo what you have just said. Definitely, if you are looking at buying a property in the near future, or if you have a property that, after listening to this video, you realize you are not properly protected, pick up the phone and give attorney Nicole Reeves LaVallee a call. Her team and herself are just fantastic, very knowledgeable on this topic, and they've been doing it for 20 years at least, right?
Yes. Stop making me feel old, even though I killed you.
I know, she always says that. All right. Well, I want to thank you so much for giving us this advice today, Nicole. And I know that lots of people are going to benefit from it. So we really appreciate the time.
Thank you.